Hey, I'm going to... What happened?
I think...
It's working? Okay.
Yes.
Introduce our next guest, next speaker. Just to say that you've all heard that Colorado and Washington State were the first two states to legalize recreational marijuana. I'd like to adjust that statement. Actually, Colorado was first and Washington was second because our polls closed an hour before Washington State polls closed. So this was a constitutional amendment voted on by the members. Yes?
Actually, Alaska did it back in the mid-'70s.
Wow.
We're doing it
So
again.
why did it such a big deal? Well, whatever. I wanted to mention some other Colorado special things first. Colorado was the first state to legalize abortion in the United States. You know that? Back in '74, I believe. And I think Colorado was the only state that was awarded Olympics, the Olympics, Winter Olympics. I think it was '76. And we said, no, we don't want the Olympics. Special things about Colorado, no. So, Robert, where are you?
Where am I? I'm right here.
Oh, there you are. Okay, Robert described himself as a community activist and gadfly, and I know that he's very knowledgeable about marijuana, so here you go, my man.
Thank you. I'm sorry about or a fleshed out history. Most of my history will begin when I moved to Colorado, or actually to Denver, and got involved in activism. But a little bit of older history. In 1937, the Marijuana Tax Act was passed, and I understand, the very day that it passed, federal agents arrested two men in Denver, Mr. Caldwell and Mr. Baca, who were given a very brief trial and then sent to Leavenworth for a minor cannabis transaction. And it is also reported, and I have not been able to come up with lots of sources, a good account, that it is claimed that Harry J. Anslinger, the commissioner of the Bureau of Narcotics, was between trains at Union Station and actually attended that trial. First it says he was incognito, and then it also, the account suggested that he spoke, hardly supporting the severe sentences meted out to these two people. The year prior, Governor Edwin C. Johnson of Colorado had sealed the border with New Mexico to prevent migrant Mexican farm workers from making their way into Colorado. And it may be that his concerns were exacerbated by statements that had been coming from Mr. Anslinger in the years leading up to the passage of the Tax Act. But I have not been able to verify that. So I will fast forward past the Marijuana Tax Act and many years of intervening history to, I believe it was 2005, although I wasn't here, when Mason Taverd, working with the Marijuana Policy Project, identified Denver as a place that would be likely to rescind municipal penalties for possession of cannabis. And a successful campaign was launched to rescind the municipal penalties in that year in Denver. Whereupon the city started enforcing the state statute against possession of cannabis more vigorously than it had its own. I moved to Colorado in 2004 and was unaware of our progressive stance on cannabis. But in 2006, Mason ran an initiative to add the words "under the age of 21" after the word "persons" in our statute prescribing possession of cannabis, thus applying it only to adults. That initiative failed by 20 percentage points in that year, possibly because the Legislative Council wrote in the Blue Book sent to every voter in the state to claim that passage of the amendment would permit the transfer of marijuana to minors, which was not true, but it was a damning point against it. And as I say, it failed by a massive margin. In 2007, I moved to Denver and discovered that there was a campaign underway to make a follow-up on rescinding the municipal ordinance. We passed an ordinance requiring that enforcement of the state statute be the city's lowest law enforcement priority, and setting up a commission that was supposed to eventually recommend that we stop doing that. The city set up the commission, but ignored the declaration that enforcement of the statute was its lowest priority, and proceeded to charge people with possession of cannabis until the present. In 2000, this is just a recounting the facts. I'm afraid I'm a little tired today. I'm not presenting as well as I might. In 2008, the Obama campaign signaled to a California group called Citizens for Safe Access that it would deprioritize enforcement of federal law in medical marijuana states. Colorado, I should say, in the year 1998 had put an initiative to pass a constitutional amendment permitting medical marijuana on the ballot. They voted to do that, but it was not placed on the ballot in 1998. And if you look in the Constitution of Colorado, the amendment authorizing medical cannabis tells the General Assembly that they have to act to write the enabling legislation by 1999. Well, in 1998, the Secretary of State, for whatever reasons, retained 66 pages of petition signatures in her desk, and I believe died in office. And the signatures were subsequently discovered, and the Supreme Court placed the initiative on the ballot in 2000. So in that year, Colorado voted for medical marijuana by, I'm not sure what the margin was, but by a fairly substantial plurality. But when you look at our Constitution, there is this anachronistic date because of the actions of the Secretary of State 2 years prior. The Colorado's medical marijuana amendment provided for doctors to recommend cannabis. It's not called a prescription, since that refers to federal authority. But doctors were permitted to recommend cannabis from that time until the present. We still retain it's part of our Constitution, Article 18, Section 14, for severe pain, chronic nausea, and the like. Doctors may recommend cannabis, but not much was recommended. There were no dispensaries, and there was no large-scale consumption of cannabis until the Obama campaign signaled to the citizens group in California that they would stop enforcing or stop making marijuana enforcement a federal priority. At that point, interest in our medical marijuana law picked up, and dispensaries began to open without any state regulation or local regulation. People simply opened up storefronts and started selling cannabis. The basis for this was the peculiar language in our Constitution, which says that people who are not medical marijuana patients, not engaged in the medical use of cannabis, will continue not to be allowed to distribute, cultivate, dispense, or sell cannabis. And it was inferred that if you were a patient and engaged in the medical use of cannabis, that you might do all of those things. And on that basis, many people decided to open dispensaries, and they started exploding in Denver and in Colorado Springs on the Front Range. A large number of dispensaries opened up. With the election of President Obama in 2008, our medical marijuana, as I say, the number of dispensaries increased greatly, And the first reaction from the establishment began to kick in. Caregivers were the people authorized to supply patients with cannabis under the Constitution. And the Department of Health was charged in the Constitution with regulating cannabis. But despite the fact that the people of Colorado found that in 2000, when they actually got a chance to vote on it, that marijuana is medicine, Colorado's medical establishment did not share that determination and tried to, mostly just kept it at arm's length and has continued to. But in 2009, there were efforts to restrict the ability of caregivers to transact cannabis, which was pretty open-ended in the Constitution. Very little specific is in there that could be interpreted as restricting what they do. And there's no definition of what a caregiver is except someone with significant responsibility for managing the well-being of a patient, to quote directly from it. So at that point, the Department of Health attempted to impose requirements on caregivers in line with the common understanding of the term. They wanted to turn them into glorified personal assistants, and so they were writing regulations that would have required that caregivers take patients shopping or to act as a personal assistant. We defeated that by one vote before the Board of Health in a marathon session that lasted, I believe, from 9 in the morning until 11:30 at night. And that was sort of the high point of cannabis activism in Colorado. Later that year, I believe it was in October, the Deputy Attorney General David Ogden released a memo from the Justice Department stating that it would no longer be a federal priority to enforce the Federal Controlled Substances Act in medical marijuana states. But it is full of equivocation and did not set up any clear guidelines. The Colorado General Assembly and Colorado's establishment realized that there was a wide open scene in cannabis and a burgeoning economy over which they had no control. And they decided to act in the 2010 legislative session by trying to take from caregivers the authority to dispense cannabis. They couldn't overturn the Constitution, of course, which is the supreme law of the state. And our Constitution, Article 18, Section 14, providing for medical marijuana, says that the state mentions the state health agency 16 times. Nonetheless, in the view of the General Assembly, cannabis and the use of cannabis remains a vice, and so they decided to give the Department of Revenue authority over dispensaries, even though all those dispensaries operating at the time were ostensibly staffed by caregivers providing cannabis to their patients. And so there was a number of us who counted ourselves constitutionalists argued for patients' rights and against the proposed legislation, which nonetheless passed. And that established a system, sort of an uneasy sharing of responsibility, where the Constitution provides for the means by which people may obtain recommendations for cannabis and invests the Department of Health with authority over the register of patients. And yet the dispensing of cannabis was, the Department of Revenue was empowered to oversee that and set up regulations to try to prevent its diversion and misuse. And the state proceeded to set up a fairly unwieldy system that has never been implemented. The intention at the start to regulate marijuana from seed to sale has never been realized. But it did provide a state framework, legal framework for these activities to take place. Of course, all of this is in direct contravention of the Federal Controlled Substances Act. And so during this entire period, people have been trying to divine what the federal government would do, what their stance really was. And it has been unclear. All they were willing to do in the Ogden Memorandum was to simply say that it would not be a priority to act against people in clear compliance with state medical marijuana laws. So we have state medical marijuana proceeded to grow, and there were the legislation that permitted sales generally throughout the state allowed localities to opt out, and many did. But it's been clear the people that wanted to pass the medical marijuana amendment, it was their intention to end the prohibition of cannabis, and activists in the state who support patients, as I did, most of us wanted to remove criminal penalties for cannabis generally for adults. And so we have been working towards that end. A national coalition of drug policy organizations, including the Marijuana Policy Project, the National Organization for the Reform of Marijuana Laws, Stop the Drug War, the Drug Policy Alliance, all the people that were organized decided to back the system that the state put in place and drafted Amendment 64, which has now been passed, to build upon that system despite the uneasy relationship between medical cannabis and, frankly, the unconstitutional statutes that what many activists in Colorado still think of as unconstitutional and inappropriate state regulation of medical marijuana. The national organizations wanted to build upon that because it seemed to be working. And their overall motivation has been to try to drive forward the commerce in cannabis as representing a fact on the ground which might lead to reform of federal law. Whereas many people, including myself, continue to be seized with the unjustness of our laws against cannabis and other drugs. The civil rights argument has not had much traction over the years. And so I've been willing to cut them slack while being uneasy about the notion that the commerce would set right our laws. So the Amendment 64 provided for a local option system for localities to opt in or not, and for the state to license general retail sales of cannabis to adults. And the campaign was funded largely from out of state. The initiative was written mostly by these national organizations and, in a sense, imposed on us. And yet, it is true that Colorado has been coming around to the idea that cannabis is not dangerous and that we can live with it, that adults may use it without causing the end of civilization. And so the campaign was wildly successful. When Amendment 64 passed in November, it passed with a plurality of almost 10 percentage points. And so in political terms, we see a radical shift over just 6 years. As I mentioned, in 2006, Colorado defeated Amendment 44, which simply would have decriminalized adult possession of up to an ounce of cannabis. We defeated that by 20 points. And six years later, we approved by 10 points a far more expansive measure, providing not just for possession of cannabis, but for its personal cultivation. We may now cultivate up to 6 plants, no more than 3 flowering at a time. We may transfer cannabis without remuneration to other adults, up to an ounce, and localities that approve the sale of cannabis may do so. So it's a fantastic political shift of even if you thought of these two initiatives as having similar provisions, and they really aren't, since the one is very much more extensive than the other, to shift 30 percentage points on the issue within just 6 years. It's an amazing change. And so where is Colorado now? The national media has picked up the refrain that Colorado has legalized cannabis. And in fact, under our Constitution, it is legal under state law for those various things I just described to take place. We may possess it, we may grow it, we may use it. It may be sold under certain circumstances. However, the General Assembly, as they passed the enabling legislation required this past legislative session, they also took the time and effort to reinstitute all the felony penalties for cannabis. And in one case, I believe, even to ratchet them up. It is now a Class 1 felony for an adult to transfer 2.5 pounds or more of cannabis to a minor. This represents the determination of prohibitionists in the General Assembly and out to take a stand against cannabis use by minors. And even though we do a very ineffective job of keeping it out of their hands at present, they undertook to increase criminal penalties. But in fact, there's a very strange antinomy where, although people may, in January, we will be licensing the sale of cannabis generally to adults in dispensaries in many places in Colorado, well, mainly in Denver on the Front Range. But at the same time, the activities we are licensing inside dispensaries will continue to be felonious when done outside of the system. And so there remains plenty of scope for all the many narcotics officers still employed to work. And we continue to arrest, convict, and incarcerate people for cannabis. An interesting situation has arisen where the disparity between people's understanding of the law and the reality of it have led to any number of people being put in severe legal jeopardy. And there is the case of commerce in cannabis over Craigslist is a case in point. There are very many ads appearing in Craigslist now from people who will offer to come deliver you some cannabis for a fee. But they have been persuaded that if they put the disclaimer that they are compliant with Amendment 64, or that the money that they are expecting from cannabis is a donation rather than a payment, that they are acting in compliance with the law, when in fact they aren't. And in Colorado Springs, after a lieutenant in the Narcotics Bureau made a highly misleading statement saying that this could not be prosecuted, in effect, he essentially declared it illegal to drive around the city and deliver cannabis and accept donations for it. A man stenciled a van, Billy Goat Green MMJ, and proceeded to drive around the city, having read this quote from the lieutenant of the Narcotics Bureau. And he was subsequently arrested and charged with many serious felonies, which could have put him away for life, having had a criminal record and done time in Colorado prisons. This man was distraught. He didn't see it out, and I've been following the case with some interest. This just happened about 6 months ago. He was arrested. Just recently, the news was reported that he had shot his wife and himself with a shotgun, killing both of them. And this is a little bit of a counterweight, I hope, to all the happy talk about, I think of it as happy talk, of Colorado having legalized cannabis. We've legalized cannabis in a limited sense, but we have reinstituted felony penalties ranging all the way up to felonies on a par with premeditated murder. And so there is, I guess I'm moving into the outlook for cannabis. The outlook is that it will be sold, and we certainly hope to remove the remaining criminal strictures against adults using it. But there is a very long way to go, and it is far from a foregone conclusion that that will happen. Just 3 days ago, Deputy Attorney General James Cole, in a further clarification from the Federal Justice Department, released a memo that somewhat less equivocally says that the federal government will not interfere with our state laws and their operation. It specifies 8 federal priorities for enforcement, but it does lend credence to the notion of supporters of the commerce in cannabis that by proceeding with state regulation that attempts to address some federal concerns, and foremost among them access of cannabis to minors, diversion to other states, and several others. If state regulation does address those concerns, then it will not be a priority for them. The Drug Enforcement Administration only has a budget of $2.6 billion every year, and so they can't break down every door or seize all the cannabis people might have. And so they appear to be backing off. This is, as far as I can tell, this is just a personal policy of this president, and we might well see these policies reversed. Just last year, the U.S. Attorney in Denver closed 70 dispensaries by fiat on the basis of an ad hoc rule that U.S. attorneys had come up with based upon the Federal Controlled Substances Act. There are enhanced penalties applied when people are convicted for any number of sorts of conduct involving cannabis within 1,000, that takes place within 1,000 feet of a school, park, or library. Of course, this is a provision of law, not a rule, but U.S. attorneys in California and in Denver decided to act against dispensaries who were, and grow facilities who were operating within 1,000 feet of a school, park, or library by threatening them with prosecution. Because presumably these people would be an embarrassment should the department decide to proceed with prosecution. They would be sending them away for 20 or even 40 years in some cases. So in California, they closed Melinda Hagg, the U.S. Attorney for Northern California, forced the closure of the Marin County Patients Collective because it was within something like 925 feet of a disused baseball diamond. But this is a logic, peculiar to U.S. attorneys. The nuances are lost on the public, but in fact, as to how and why these dispensaries were closed. But on the basis of this ad hoc rule, 70 dispensaries were closed with little more effort than a threatening letter. The DEA kicked in the doors of 5 to make sure they were no longer operating. But my point being that although federal enforcement in Colorado and Washington would cause economic dislocation and problems, certainly for the states that have become dependent upon the revenue generated, because in Colorado, state sales tax has been being applied to what is supposed to be a medicine and not tax, and the state has realized substantial revenue from it, as have localities through their local auction sales tax. But all that notwithstanding, the federal government could roll up the legal state-regulated commerce in cannabis quite easily. Under Colorado law, the feds may request, the Department of Revenue may disclose to any law enforcement agency upon request the locations where cannabis is being grown. And of course, it's a matter of public record when people receive licenses. So the state regulated system may provide a model for how the laws against cannabis could be liberalized federally, but it also puts the people involved in jeopardy. And so we really don't know where things are going. As long as President Obama and his policy remains in place, the states will be allowed to go their own way. And that will end in another 2 years, 3 years. And so we don't really know what the prospects are. We hope that we are going to adopt a rational policy towards cannabis. But there have been efforts to reschedule cannabis to protect states federally, through federal law, that are experimenting with cannabis. But no one has proposed to abolish or substantially revise the Controlled Substances Act yet, and that would have to be done before there could be any measure of security in state cannabis. So that's some idea of where we've been and where we're going. It is now legal to be given cannabis in Colorado or to grow it, but I'm afraid you can't yet walk into a dispensary yourselves and purchase some. But if you come back next January, we'll be able to. And I would be glad to take questions.
Well, you said that it was allowed 1 ounce between individuals and stuff, but the penalties were actually increased for outside of that. What do you mean by outside? In other words, if you exchange 2 ounces, then or you grow more than 6 plants. I mean, where are the penalties?
The conduct that is protected is the personal use and possession of up to 1 ounce of cannabis and the cultivation of up to 6 plants, no more than 3 in a flowering state at any given time. And the state-regulated sale is provided for by the Constitution now. But all the felony statutes, which were on the books before, with the exception of those, exceptions have been made because of the Constitution for that I just specified, but all the other conduct involving cannabis, which was felonious, its sale, not regulated sale, its distribution, its cultivation beyond 6 plants, all the felony statutes which were in place, with a few minor modifications, remain in place. And felony penalties ranging all the way up to a Class 1 felony were just reinstituted as of this past legislative session. If that's...
Yeah, so basically if you want to go into business selling it, you need a license.
Yes.
Okay.
But my main point is that there is still plenty of scope for the state to arrest and convict people for conduct involving cannabis, and it is a felony. The other important, what I consider to be an important aspect of the amendment, for all of various aspects of it that those of us who supported the medical marijuana amendment disliked about Amendment 64, it includes a section that is not legally binding, a prefatory section described as the amendment's purpose and findings. And in the statement of purpose and findings, it says that the people of Colorado declare that cannabis should be regulated in a manner similar to alcohol. As I say, this is not legally binding, but under Colorado's liquor code, the most severe penalty provided for is a misdemeanor. But in the Uniform Controlled Substances Act, there was this galaxy of felonies. And so an excellent case can be made that the intent of the people was to eliminate felony penalties for cannabis. That this message has not reached our legislators, except by me screaming at them through a bullhorn, mostly, yet. But I'm planning to file an initiative, a constitutional initiative, which I don't plan to carry to the ballot because it requires a great deal of money and effort. But I will file an initiative for the purposes of publicity, at least, that proposes to rescind all felony penalties for any conduct involving cannabis by adults, because that is consistent with the Constitution. But we haven't come around to that idea. The establishment doesn't like cannabis, but they are becoming increasingly dependent upon the tax revenue, which was, of course, the strategy all along. they were not ready to cut loose all the people, parasites, as I describe them, whose livelihoods depend upon the continued illegality of cannabis. And that's why a lot of my, I have directed a great deal of animus against those people, because they are a large part of the problem. It's not simply a process of enlightenment of society that we realize that cannabis itself is not so harmful, but that we have misdirected society's efforts and treasure towards attempting to suppress it and persecute its users. And most of that apparatus remains in place. Yes?
Concerning the states that surround Colorado, I know Wyoming is considering, or at least some people in Wyoming are considering bringing forth an initiative similar to Colorado's. But in my own state, Nebraska, there's been talk in the state legislature of closing every one of the agricultural roads that goes across the state line and only keeping open the paved roads. And at least three southern counties in the Panhandle have thought of the idea of walking the border with Colorado with armed civilian militias. And well, how are the other states taking Colorado's initiative?
Well, I don't have a lot of specific information, although we are constantly reading. I get alerts sent to me when there are media reports mentioning both Colorado and marijuana on the same page. And so when people take it across the border and are arrested, I often see these anecdotes. It's just my impression is that if one has a car with Colorado plates and you leave Colorado, you are subject to an illegal search. And 60-year-old women have been traveling alone, have been stopped on the slightest pretext. And
having been in the military, where in the past, where searches at gates, for example, are perfectly legal, you had to take your car to a mechanic. Mechanic has something in the car that shouldn't be there, then you get busted for it when you come through the gate. Going home, our car was in a mechanic before we came to the GGG. Now we go home to Nebraska, and these folks that are threatening to use civilian militias to guard the border, what happens to folks like us?
You get illegally searched is the short answer. And it is an ongoing problem. And the states surrounding Colorado, it is my impression, all of them are substantially more fascist.
I have a question about the medical use. I was assuming / hoping that legalization would lead for standardization, and I know this is an agricultural product, so THC potency will be based on strain and maybe horticultural methods, and we have a number of factors. I read an article recently about parents of a 3 or 4-year-old girl, thankfully in Colorado. She was suffering from dozens of grand mal seizures daily.
Charlotte Figge.
Yes.
The case of Charlotte Figge has been very. That is a signal case, as it may have led to Governor Christie of New Jersey modifying his stance against children's access to cannabis. It turns out that CBD, cannabidiol, one of the active cannabinoids in cannabis, which has something on the order of 400 biochemically active cannabinoids, apparently has great promise in treating, I think, not just Dravet syndrome, but there are other refractory epilepsies of youth, of which it is one, that have a genetic basis. And Charlotte Figge's parents had signed a do not resuscitate order for her because she was getting worse, and no conventional treatment had been able to deal with her constant seizing. But cannabidiol treatment almost completely resolved her problem, and she is now developing normally, it's my understanding. And while that syndrome affects a very small number of people, it is indicative of this larger problem of treating cannabis as medicine. The people of Colorado in the Medical Cannabis Amendment of 1998 or 2000, passed in 2000, declared cannabis to be a medicine, but the medical establishment did not convince anyone. And the Department of Health and Environment has not undertaken any study of cannabis. It has not certified any new condition other than those specified in the Constitution for treatment by cannabis, and it has done as little as it possibly can other than maintaining the register of patients regarding medical cannabis. And it's indicative of a degree of scientific incuriosity on the part of the medical establishment, which is shameful. But we know that there's an explosion of interest in cannabidiol in particular. But there's many studies being done now showing efficacy in the treatment of post-traumatic stress syndrome, epilepsy, other multiple sclerosis, and not just in palliation.
To follow on to that, so I'm curious about the standardization aspect, though. These are parents of a 3-year-old whose body weight and tolerance will increase over time. Are they the caregivers who are then liable for testing and verifying the THC content each round? When it's Farmer Bob growing this without regulations?
No, the description of what caregivers were and what they did in the Constitution is very vague and limited. And caregivers have been largely superseded. The state wanted to cut them out of the money, and that's why in 2010 it passed regulations establishing the state-regulated system. There is now going to be, they're finally moving to come up with requiring that they put information on the content, the THC and CBD content, and people are beginning to do that. There are laboratories that are testing it. But as far in Charlotte Figge's case, I believe the Figges had to contact something on the order of 36 dispensaries before they were put in contact. Found one that had a high CBD strain, because although, and of course, many people that do not absolutely need cannabis to survive have become medical marijuana patients. I did not mention that. It's a fairly obvious point. But in that process, people have been selecting strains of cannabis that are extremely potent in either Delta 8 or Delta 9 THC. Cannabis sativa tends to have more Delta 9 THC, which is more cerebral effect, and Delta 8 THC is described as having more of a body high. But neither of these are cannabidiol, or all of these don't have the same properties as cannabinoids found to a lesser extent in cannabis. And so there aren't many strains, or it has not been, paradoxically, despite medical knowledge that CBD and other cannabinoids were maybe of greater interest than THC. People have been selecting for THC because that's what gets you high.
I have some information about that.
Certainly.
In California, where the medical dispensing of it, you need a prescription, is allowed. Again, that's only state. The feds can come in at any time and shut a place down on their own authority. But there is some. Obviously, you're not going to have a 3-year-old smoking a joint or something. The edible forms, which are. Sorry.
You can have my microphone.
Thank you.
So in California, the edible forms, which is what especially young patients would be using, do have some, I don't know the right term, but prescriptive information about levels of some of the active ingredients in it. I don't know personally how officially standardized those are. They appear to be standard. They look like the labeling that you would get on the nutritional value of foods that you would buy out of the grocery. So you, based on that, could determine dosage levels, assuming that they are, actually standardized. Again, I'm not positive about that. And my other understanding is that one of the problems in getting standardization is that you would have to do officially, federally recognized research, which can only be done by obtaining cannabis from a particular farm. I think it's in Missouri, and the process for getting approval to do that is so difficult that virtually nobody does. I mean, it takes months or years just to get it approved, and you're subject to all sorts of inquiries from federal authorities, and it's just that's part of the process of getting any sort of standardization is that nobody is really encouraging it.
For those most effective medical strains, do you know if they're attempting to synthesize those to enable mass production?
I'd like to weigh in on that. I don't think it's not quite correct that standardization is dependent upon federal action because we have had there are several laboratories performing reliable tests. That's the basis of the state requirements for labeling in Colorado. The federal government has had a program supplying patients with cannabis from University of Mississippi, I don't know what it is, for years, but they stopped accepting new patients long ago, but they had an investigational drug program going, and still do, where people are sent metal canisters full of joints. I'm not sure how many people that are left in it, but it's fewer than 6. It's just a handful of people. But standards, in order to study it in a research setting where that is supported by federal tax dollars, there will have to be major reform of the Controlled Substances Act. So that is the proper medical research has been stopped and suppressed by federal law. There's the National Institutes for Drug Abuse have funded studies which seem to be aimed at showing harm from cannabis as opposed to other purposes. We have a propaganda arm of the government in the executive branch, the Office of National Drug Control Policy, which the reason for its existence is to disseminate false, negative information about cannabis. So, and the Drug Enforcement Administration has had a lockhold on the distribution of it, has been able to prevent cannabis going to researchers to study it. So in many ways, the federal government has suppressed it. And even locally, one laboratory, Full Spectrum Labs, was raided by the DEA. No one was arrested and they didn't take their equipment, but they confiscated plant material that they were using as a reference to calibrate their chromatograph, I believe. And so while it's been difficult, it's difficult to proceed with the realization of the medical potential of cannabis without federal approval and involvement. I don't really know to what extent that can be done, and I don't know that it has been plumbed in any of the medical cannabis states, because if the situation in Colorado is indicative, our medical establishment is so hidebound, is so money driven, and it's completely dependent upon the federal government that it has no interest in pursuing any of those things, and so the people left to foment this research are just individuals who've been helped, some of them doctors.
I know.
Actually, I think that's a perfect lead into my contribution to the discussion. After I retired from my office practice and I was looking at Craigslist for things to do, one of them turned out to be a medical marijuana clinic. And so I looked into becoming a medical marijuana doctor because I believe in the proper use of marijuana for medical purposes. When I talked to some people who worked at the clinic and also talked to the director, their point about the economics goes both ways. The way medical marijuana clinics almost always, in fact I don't know a single one that's an exception, compensate physicians is based on the number of patients you see, and the number of patients you see, of course, is driven by referrals. So if you're and the patients walk in there, they don't have to pay if they don't get a prescription. And so the driving force is to create as many prescriptions as you can, and the indications, the possible indications are so broad. In fact, you mentioned some of them: stress, depression, almost anything that a normal person would have, that it's very easy to create a medical record that documents that somebody had something that made it appropriate to give them medical marijuana. And so the entire economics of the system is driven by somebody walks in, wants some grass, you give it to them. The next thing is that there's a doctor who I'd spoken to, actually was still working for the clinic, but she was fairly put off by the fact that when she went to a medical convention that was specifically for physicians who are medical marijuana doctors, the air was so thick with marijuana smoke from those doctors who were attending it that it was pretty clear, I mean, unless all of them had some medical condition, which I rather doubt.
This was in California.
This was in California. No, I'm talking about California. But I would challenge you to find a medical marijuana clinic in some other state that doesn't compensate its physicians in the same way, that doesn't charge its patients in the same way, and that therefore doesn't have a system which is economically driven to foster giving a prescription to whoever walks in. Now, the last thing I'll say is that, and I guess there sometimes is the last thing that I say, is that as a school board member in a school district in California, in the Silicon Valley, high-tech area, but also an area with significant gangs, significant poverty. We're not right on the, gang distribution corridor, but we're not that many, maybe 40-minute drive. What we run into with marijuana use and sales by children is outrageous, and we don't even get the snowflake on the tip of the iceberg. And there are parents who basically come to pick up their kids at school wearing their gang colors. So this is not an issue, well, the parents just need to monitor them carefully. It very well is often an issue of the parents fostering the children, the kind of behavior that is in the culture of the home, which may explain how some of the marijuana gets there. So I think all of these things are things that activists like yourself need to take into account as to how, when we make sure that we finally are able to get cannabis, marijuana, whatever, cannabinoids, to the people who really need them for medical problems, for seizures, for glaucoma, etc., that we also do it in a way that we're not simply giving dope to everyone who wants it, and that we're not making the already severe problem of drug abuse in our schools and children worse. I don't know what answer you have, and I don't expect you to have an answer.
Well, I'd like to address that. First, I'd like to correct one thing. I mean, we shouldn't use the word prescription in reference to cannabis. Recommendation is the preferred word. And in Colorado, under the Constitution, a doctor is not supposed to recommend cannabis unless you suffer from severe pain, chronic nausea, or cachexia. That's essentially it. But so that severe depression is not an indication. Access to cannabis by minors is a problem, but I don't see it as being a problem in rural. It really, to me, it doesn't relate strongly to this effort. Although the argument has been made by proponents of the amendment that a regulated market at least gives you the means by which you could proceed to prevent sales to children, at least some sales, except that, as it happens, the will to enforce the law isn't there. So, I mean, we have a bizarre, it is a strange situation that our legislators consistently are persuaded to want to ratchet up the penalties for transferring cannabis to minors. And here, as I said, we've now made it a Class 1 felony in some circumstances to do so. And yet, we aren't that concerned when students are coming to school stoned. And I just concluded a very brief teaching experience in a local charter school. A half an hour before I was fired Thursday, the woman who fired me, I observed an interaction with her and one of the students. The student said, "Miss Judy, may I get my vape pen back?" Well, a vape pen, that's short for vaporizer pen. It's essentially the same thing as an e-cigarette, except that designation indicates it's to be used for vaporizing cannabinoids. And this, I'd already heard indirectly. I heard students over talking about having gotten high at lunch. We didn't let them out at lunch because they would come back too stoned from having smoked pot outside, but they had gotten around that by bringing in a vape pen. So this vape pen was very likely charged with cannabis concentrate, and Miss Judy knew it. Well, under Colorado law, that's a Class 4 felony, but a felony nonetheless. So, the real issue here is not whether or not people that don't. We are beyond the medical discussion at this point. We have determined that adults can be trusted with that decision. But the real issue is that as a society, we don't have a consistent stand against even children having access to cannabis, and it's the parents that are the real sticking point. If the parents don't care and have no control, and so a regulated market where no child is sold cannabis is entirely possible. It is possible to enforce laws against selling children tobacco, but most people who become addicted to tobacco are becoming addicted as children and probably at or within a few blocks of their schools, and they're able to obtain the highly addictive drug that will eventually kill them, and which kills approximately 435,000 Americans every year, right next to their schools. There are campaigns to try to get people concerned and apply pressure to retailers and to law enforcement and all the participants in the process to enforce those laws. But it's a poor argument, it seems to me, that a regulated market could prevent access by children. It surely can't hurt. If we have these laws and if people are checking IDs, then it does undercut the black market. The problem we have is that we are still leaving cannabis a middle to upper class phenomenon. The cost of it, in the Constitution, we authorized a 15% excise tax to be applied to wholesale transfers of cannabis. The General Assembly, being a separate branch of government, did not have to do that. The Constitution says they were to refer an initiative to us, asking us to raise it up to a 15% excise tax. The General Assembly didn't do that. They referred a different initiative. Their initiative says that asks us to impose a 15% excise tax on wholesale transfers of cannabis and a 10% sales tax surcharge only on cannabis, absent any real justification for it other than that they are greedy. So we are pricing it. We are still pricing it very high, and we are retaining a completely criminal system for dealing with people that operate outside of that. So we haven't undertaken the steps we would need to completely eliminate the black market, and that would be necessary to create a situation where children might be restricted from access.
Naive question, but isn't this comparable to when we moved out of the Prohibition era and alcohol became legal again? Aren't there some?
I believe it is. There were doctors. The prescriptions, medical prescriptions for alcohol, soared during Prohibition, is my understanding. And yeah, there are similarities. At least I'm not well apprised of all of them, but yes. Yeah.
Can we just have one more question, please? We're over time.
Oh no, let's go on.
You cut me off. There's a speaker waiting that is supposed to have started half an hour ago, or whatever. Okay, go on. Yeah, that's going to be very brief.
Some of the funding for this initiative came from Dr. Bronner's and others who are using industrial hemp from other countries. They would like to grow it right here in Colorado. What's happening with that? The stuff you don't get high on with the tube, the ropes, or hemp oil and that kind of stuff.
I might have mentioned that. We did also legalize hemp in the Constitution. There are supposed to be 55 acres in the ground out in Springfield. There is a tremendous opportunity. I mean, the value of these products as raw agricultural products is not huge, but our consumption isn't great. Rope is the least of the nutritional properties of hemp seed are remarkable. It has what is supposed to be the ideal ratio of omega-6 to omega-3 fatty acids. 3 to 1, which is what the Paleolithic diet is supposed to have consisted of, and so hemp seed is showing up in health food stores. It's imported from Canada because right now it must be, but all sorts of products are being made with it: waffles, cereals, hemp milk, In Colorado, you might be able to find some hemp ice cream. I've helped sell that. This is not intoxicating. It's simply ice cream made with the milk obtained from the seed, the meat of the seed. It's prodigiously expensive. Hemp seed on sale at Vitamin Cottage right now, $4.55 for an 8-ounce package. And it's delicious. It's very nutritious. Between its use in building products, hempcrete is an excellent insulator. The fiber makes for good clothing if you have a textile industry to process it. There's tremendous potential. I'm most interested in the nutritional aspects of it, but yes, it's going to be legal, we hope.
Yeah. First of all, victimless crime is an oxymoron. Somebody smoking pot doesn't hurt anybody else. We've spent enormous amounts of money on the war on drugs, with the result that drugs are more available than they ever have been in the U.S. So I agree with your general stance. It seems to me that this is just something that we ought to legalize and get over with.
Well, thanks. But restricting access to children, it does concern me. I don't. It's not helpful. It's not destroying their brains, but it's certainly, if they're coming to class high, it certainly makes it difficult to teach them mathematics. We're not supposed to take any more questions.